Good morning, ladies and gentlemen. We're going to start the hearings in a minute, but first I would ask that Representative Moffett lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Representative. So this morning you'll see, yes, ma'am. Certainly.
Thank you. I'd just like to take a point of privilege. So there was an article I read this morning in the Union Leader that brought this up for me, that in the past on this committee, we've done, it's important for us to make sure that we're doing what's best for kids, and that can be incredibly complicated. And so what we have done in the past is really utilize our committee researcher and make sure that we are getting things just right, that we have full knowledge on bills, that we're really looking past our own limited knowledge to make sure we're doing what's best for kids. And we're also, our time frame between our executive sessions and hearings is so short. It leaves very little room for in-depth discussions, in-depth looking into things. I do hope that in the spirit of doing what's best for kids in this state, we can move back to something like that so that we're really taking our policy seriously. Thank you.
You're welcome. Thank you for your comments. Representative Rice, you're recognized for personal privilege.
Thank you, Madam Chair. I would just like to say that we're not going to agree on everything. And just because we don't agree does not mean that one side or the other does not believe it's what's in the best interest of the children. Thank you.
Response.
Thank you.
Due diligence
It's
is
okay.
important regardless.
It's okay. Thank you very much. And now I will open the exec session on House Bill 1036. I believe that when she's ready, 1036 is Representative, Jody's making the motion. Yeah, okay. Representative Nelson, do you have a motion? And that's for, I apologize.
Okay.
Wait a minute. It's Lori. Representative Corzine.
Thank you, Madam Chair. I move to vote ITL on this bill.
I'll second. Would you like to speak to your motion?
Yes, please. I think that it's a good meaning bill, but I think that it puts longer marriages and those who maybe are older at a great disadvantage. If somebody's married for 30 years and then they only get 8 years of alimony, it's not very fair. That's why I would vote ITL.
Thank you. Any further discussion? Representative Georges?
Thank you, Madam Chair. I just want to say for me, that is right. For 30 years of marriage or 20 years of marriage and now just 8 years, but sometimes the wife doesn't even have nothing to do and then she's struggling. I think so. 8 years is less.
Thank you. Any further discussion? Seeing none at this time, I will ask the clerk to call the roll, please.
Representative Wright. Yes. Representative Pearson.
Yes.
Representative McMahon.
Yes.
Representative Nelson.
Yes.
Alan,
doesn't,
Representative Markel, you're being called on to vote.
As to ITL, I
Yes.
support ITL.
Representative Petrino,
Yes.
Representative Scher,
Yes.
Representative Levesque, Representative Gray,
Yes.
Representative Raymond, Representative Georges,
Yes.
Representative Malone,
Yes.
and Chairman DeSimone.
Yes. Considering the fact that this was unanimous, do I hear a motion for consent? Representative
Second.
Rice moves consent. Do I see any objection to that? Consent it is. What is the vote, Madam Clerk?
15-0.
15-0. And Madam Clerk, you do, Representative Corzine, you do have your
Yes,
ready?
yes.
Thank you. We'll give the clerk a minute or so to get her things in order, and then we'll move on.
Yes. Yes.
You're so quiet. You're so quiet. You're so upset.
Just wait.
Yeah. I know.
We're going to close the exec on 10:36, and we're going to open the exec session on House Bill 1225. Do I hear a motion, Representative?
Yes. I move to adopt the amendment which is being placed in front of you on 1225.
Can you do the amendment number?
Sorry? Yes, I'm sorry. It's 0599H. And what this amendment does is that it clarifies some of the language from the prior bill to make it clear as to what the deductions are going to be for the obligor. And in specifically, if you look at the bolded language, a self-employed obligor, it's 50% of the actual self-employment taxes paid. And then if you look at the bold language on paragraph F, if an employee obligor, that means 100% of his or her federal old age, survivors and disability insurance, Social Security program, and Medicare taxes will be withheld from a prior's pay, will be factored in to the child support adjusted gross income feature. And for those reasons, I ask it to be, the amended be adopted.
Discussion?
Needs a second.
Do I hear a second? I will second that. For discussion, Representative Pearson.
This probably won't apply to me for quite some time, but what is old age? I don't know, I mean, I know what old age is, but I
Okay.
don't know it in terms of taxation.
Actually, it is more or less the official name of the Social Security Act. You'll also find it referred to, in the alimony statute as a deduction. And so that language came directly from the alimony statute during reform back around 2019, more or less, when this legislature did the reform. And that's basically how it's titled.
Follow up?
Follow up?
So by this reasoning, young people pay old age.
Well, it's considered retirement. That's the way the bill has been titled, so.
Thank you, I'm still a law student, you know that. So
Okay.
I haven't gotten that far yet.
Okay,
It
thank you,
must
sir.
be your old age.
Thank you, Counselor.
You're welcome.
When you're finished speaking, can you remember to shut off your microphones, please? Representative Georges. Thank you. Representative Raymond.
Thank you, Madam Chair, and thank you. So my question is for anyone who might know the answer, Representative Markell or others. When we heard testimony on this, there was testimony about how child support calculates this already as when they do, they look at the gross income and then they deduct the federal taxes out when they do it through their system. If parties aren't making their own agreement, if it's going through child support. So do we know, would this rectify that? So if someone is going through the child support unit, would this amendment make it so that it doesn't get double deducted?
Well, it wouldn't be double deducted because if you take a look at the child support worksheet, it's not evident that it's on there. So this clarifies that because it's not on the Bureau of Child Support worksheet. So number one. Number two is that when I was contacted earlier by a BCCS attorney who called me about it, and I asked him about it, and he really had no comment on it. Number three is that I saw no credible evidence presented by any opponent that it's actually factored in there. So on that basis, and the other thing being that with it, I saw when we heard this earlier, we saw a deduction of about 3.8%, 3.8 to 4% difference in the child support calculation when you factor it in. So I don't see it as a double deduction. There was just no evidence provided that that's the case.
I don't recall child support being here, so I was just wondering if we had gotten them.
But the other thing being that I'm sorry, I didn't mean to overspeak. The other thing is that the opponent to it offered no credible testimony indicating that was the case.
Well, I mean, we're not a court of law, so people offer the testimony they offer. I was just asking if anyone had talked to child support to answer the question. And if the answer is no, the answer is no, we don't, but you don't believe it.
Thank you, Madam Chair. I do recall at that hearing that, and I'm sorry, I forget his name at the moment, but that man from Matthew Hayes was sitting in the back over there. So I don't recall at the moment if he testified or not, but I know he was here.
I apologize, we were just switching. Representative Gray.
Um, Thank you, Madam Chair. And so, Mr. Hayes was here. Oh, there. Mr. Hayes was here. He did not testify and generally doesn't unless he's asked to testify on certain things. So in looking at, we also had no testimony that it was an issue, but as far as the amendment goes, I think it's fine to fix the language. What it does not fix is, it does currently say that the calculator already deducts federal taxes, Social Security, and Medicare from both parties' gross income before calculating support. So this is going to double dip, regardless of whether or not you think it does. It's already in procedure. So I know that Mary Kruger is here and she might have documentation on that, but if we're letting an expert testify, but that is this is going to create a double dipping issue. So thank you.
In reply? May I reply? Okay.
Yes.
Well, the situation here,
Representative Markel.
thank you for recognizing me, Madam Chair. Appreciate it. The situation is that withholding is very much at the discretion of the employee and the employer. So, for example, you can have more than one or two deductions, and you can adjust your withholding no matter what. Okay. So, if that's going to be putting in your deductions, how would they know that? Because they wouldn't, you're only adjusting your gross income and you're only adjusting from what's on the top lines that go into the child support worksheet. So you don't know how many withholdings you have from the federal taxes.
Thank you. I'll allow it, but I don't want to have a back and forth all day either.
Oh, of
So,
course.
but I will allow it.
Thank you. I
Thank
appreciate that. So regardless of whether or not you put it or you have a deduction, the federal government at the end of the year says, you know what, you owe this money. So it's not like we can say, well, we're not putting it in the deductions, or I'm not going to have my taxes taken out or whatever, and therefore it just goes away. That's not actually the case. It does still require at the end of the year, whether or not you're self-employed and have done these deductions that you're supposed to do, federal government requires that this is done, which takes care of that. So it doesn't matter what, if you've deducted it throughout the year, you still have to owe it. So unless somebody is cheating on something, and that's another ballgame that's beside this.
Well, I'm viewing it differently because you don't put in the number of deductions. I mean, it calculates the number of children for which a support order is based, but there was nothing in front of me, and I spoke to Bureau of Child Support. They called me on it, and then they said, "But that's it." And I asked them, and I said, "Where?" And I got no response. So where is it?
Thank you. Representative Petrino, I saw your mic was on. Do you have a question?
No.
Okay. Hi, sir. So this is on the amendment 2026-0599H. Seeing no further discussion, I will ask the clerk to call the roll.
Representative Rice? Yes. Representative Pearson?
Yes.
Representative McMahon?
Yes.
Representative Nelson?
Yes.
Representative Moffett?
Yes.
Representative Corson? Yes. Representative Markel?
Yes.
Representative Petrino?
Yes.
Representative Scher?
Yes.
Representative Levesque?
Yes.
Representative Gray?
Yes.
Representative Raymond?
Yes.
Representative Georges?
Yes.
Representative Malone?
Yes.
And Chairman DeSimone?
Yes.
15-0.
Representative Markel, do you have a motion to make?
Yes, thank you, Madam Chair. I move that since the amendment is adopted, I move that this bill pass.
No, you have to move
the-
OTPA.
I'm sorry, OTPA. I'm sorry. I'll have to pass as amended. Sorry about that.
Thank you. Do we have any discussion on the motion? Oh, I will second that motion. Do we have any discussion on the motion of ought to pass as amended? Seeing no hands, when the clerk is ready, I will ask her to call the roll.
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative McMahon,
Yes.
Representative Nelson.
Yes.
Representative Moffett,
Yes.
Representative Corzine, yes. Representative Markel,
Yes.
Representative Petrino,
No.
Representative Scher,
No.
Representative Levesque,
No.
Representative Gregg,
No.
Representative Raymond, Representative Georges,
Yes.
Representative Malone,
No.
Chairman DeSimone,
Yes.
sorry. So it's 9-7.
Representative Markel, do you have your report ready?
Yes, I do.
Okay, you'll pass it into the chair at the end of the exec session, please.
Yes, Madam Chair, I
Thank you,
will.
sir. And what was the vote?
9-6.
Will there be a minority report?
Yeah.
Who will give the minority report? Greg? Yes, you'll get it in a second. And who will do the PI for you? Are you going to speak on the floor, Representative?
I believe so, but I think we talk about that as a caucus and we'll let Mr. Smith know. Thank you.
Okay, I just was curious. Thank you very much.
One second.
Everybody's ready? I'm going to close the hearing on 12:25. And I will open the executive on House Bill 1228. And I will ask Representative Markel, do you have a motion? OTP. I will
Ought to
second.
pass.
I will second that for discussion. Do I see any questions? Any discussion? Then I will ask the clerk to call the roll, please.
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative McMahon,
Yes.
Representative Nelson.
Yes.
Representative Moffett,
Yes.
Representative Corzine, yes. Representative Markel,
Yes.
Representative Petrino,
Yes.
Representative Scher,
Yes.
Representative Levesque,
Yes.
Representative Gregg,
Yes.
Representative Raymond, Representative Georges,
Yes.
Representative Malone,
Yes.
and Chairman DeSimone.
Yes.
15-0.
15-0. I have a motion for consent from Rice, Representative Rice. I already said it. You get the next one. Thank you, dear. Any objection to consent? Thank you very much. I'm going to close the hearing for 1228, and I'm going to open the hearing for 1229, House Bill 1229. And do I hear a motion, Representative Markel?
Yes, move to amend the bill.
And what amendment number are you looking to?
Okay, just a
Would that
sec, let me
be-
pull it out here.
2026
552.
Okay.
0552H, sir?
Yes, that's the
Okay.
one.
I believe Representative Gregg would like to speak to the amendment. Is that true, Representative Gregg?
Actually, no, I just wanted to make the motion, but I'll
Oh.
let somebody else.
Ye-
I'll
Would
second.
you like to second it? Representative Gregg seconds the motion. And let me write that down. On the amendment. Markel moved it.
Yes.
Greg seconded. Okay. I first saw Representative Scher's hand up.
Thank you,
Would you like to speak to this amendment,
I
sir?
would.
Okay.
Thank you, Madam Chair. What this amendment does is if you look at lines 9 and 10, starting on line 9, after the word unconscionable, it adds a third factor to the consideration. That's a factor that was part of a New Hampshire Supreme Court opinion in 1989, and it completes it. So I'll leave it at that.
Thank you, Representative. Representative Pearson.
Thank you, Madam Chair, and I do not see an effective date on the bottom of the amendment. Is that just because it's only replacing section 1 and therefore section 2 from the original bill remains?
Correct.
Thank you.
Any further discussion? Seeing none, I'll ask the clerk to call the roll on amendment number 2026 05528.
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative McMahon,
Yes.
Representative Nelson.
Yes.
Representative Moffett,
Yes.
Representative Corson, yes. Representative Markel,
Yes.
Representative Petrino,
Yes.
Representative Scher,
Yes.
Representative Levesque,
Yes.
Representative Gregg,
Yes.
Representative Raymond. Representative Georges,
Yes.
Representative Malone,
Yes.
and Chair DeSimone,
Yes.
15-0.
Do I hear a new motion, Representative Markel?
Yes, thank you, Madam Chair. I move the bill ought to pass as amended.
Thank you. And Representative Gregg, would you like to second that motion?
Sure.
Seconded by Representative Gregg. When the clerk is ready, I'll ask her to call the roll, please.
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative McMahon,
Yes.
Representative Nelson.
Yes.
Representative Love, Representative Moffett, sorry.
Yes.
Representative Corson, yes. Representative Markel,
Yes.
Representative Petrino,
Yes.
Representative Scher,
Yes.
Representative Levesque,
Yes.
Representative Gregg, Representative Raymond, Representative Georges,
Yes.
Representative Malone,
Yes.
and Chairman DeSimone,
Yes.
15-0.
Seeing Representative Pearson, do I hear a motion?
You do, and the motion is, let's put this on consent, please.
Seeing no objection, consent it is. Thank you, Representative. while the clerk is getting ready, the next bill that we're going to hear is House Bill 1779. Representative Rice has asked to have a little bit of a discussion before we hear motions and so forth. So I would like to recognize Representative Rice.
Thank you, Madam Chair. So I think this bill has a lot of merit. I think we don't have a lot of time to work on it. It also has a large fiscal note, which will be a problem. What I would like to recommend to the chair is that she appoint a subcommittee to work on this bill over the summer and bring it back in the fall so that we get it right and make sure it passes. Right now with the fiscal note, it's just not going to go anywhere. But I do think it's really important.
Representative Scher, and then Representative Gregg, and then Representative Georges.
I agree. It's a very important bill that we need to do something with. The amendment that I filed, I'll say the number right now, 0590H. It was an effort to take the expense out of the bill by getting rid of the language specialized, making the cultural advocates voluntary, and making the fund at the end, the cultural foster care fund, make that apply only if funded, so that the DCYF didn't need to set it up. I understand the concerns that Representative Rice has identified.
Before Representative Gregg speaks, Representative Rice has a response to that. Representative Scher.
I would just like to see if we could get the whole of the bill passed in the fall during a budget year when we know better what we're looking at.
Representative Scher, quickly.
And that would be get the whole bill passed with money.
Yeah.
Thank you.
Representative Gregg.
Thank you, Madam Chair. So it's my understanding in looking at procedure and stuff, the reason this is an early bill is with that FN and stuff. But if we had an amendment that took that FN out, that made a committee out of it, or even assigned it to the child oversight, they actually have a foster care subcommittee over there, then we maybe don't have to rush this right now. We can hold it. And because I know that we all, obviously, this is incredibly important. And, to ITL something like this, it is incredibly important when we could work on it without doing that. I'm just curious, is there not any other option that you see here?
So we don't want to see it die because it has money attached, and I will tell you it will die on the floor.
Right, that's why I say
wanna
let's take
deal
an
with it.
amendment and
So
we can hold it, because the only reason it's pushing through early is because of the fiscal note. So if we hold it, because we know that we're not going to have a fiscal note, this doesn't have to push through early as that. So we can actually retain it in committee, do some work. We have
No, you
time to
can't.
do we can't not retain it, but we can we cannot push it through yet.
unfortunately, we can't. So
But we can have a
Representative Rice and I talked about having an ad hoc committee that would meet over the summer. And with Representative Georges, I spoke with Representative Scher, and Representative Malone would all like to serve on that. And anybody else who wants to
So would
serve
you table this?
we can't.
Can't you table it? You can table it.
I can't table it in committee. We can table it on the floor.
Okay,
So if we vote ITL now, and then on the floor, we can table it.
I have a procedural question.
right, and I think a table would make that. What's the procedure for referring it back to committee on the floor? Like, what is that?
It has an FN and it's the second year, so we can't recommit.
Can we step outside and make that call real quick? Or,
Madam Chair, a point of
Just a
order.
minute, I have a multitude of hands, and Representative Raymond's hand was up first.
I
So
raised a point of order.
Representative Raymond.
Thank you. So my question is procedurally, on the floor, would it, if we don't make a motion to go to consent, then it doesn't go in consent, right? So if we vote one way in committee, it doesn't automatically end up on the consent calendar
Right.
unless we
It can't-
also ask it.
We
Put it on
can't,
consent.
we can't put it on consent anyway because it's an FN and it's an early bill. So it would not go to
So
consent
it's
anyway.
going to go to the floor no matter
It will
what we
go to the
decide
floor.
do. Yeah. Okay. Thank you for answering. that
Okay.
question.
The next person that I saw was Representative Petrino.
Just a quick question procedurally. Since it is an early bill, can we table? Can bills be tabled when they're early bills
Not in committee, but on the floor.
on the floor?
Representative Scher.
So, just a question, if my amendment was adopted, technically, there would be no for the amendment, there'd be no fiscal note. Does it then take it away from being an early bill and give us more flexibility?
Well, we have to send the amendment back to LBA, right? And let them make that determination, right? Like we say that there's no fiscal note, but we have to have LBA give the final call on that.
So might it be worth doing that? LBA does what they do, it comes back to us after LBA does that, or it goes to the floor?
Well, we can't be sure that I don't know when LBA will get to this because keep in mind, they're probably being bombarded right now, right? Because it's so late.
Can we postpone the exec session till Tuesday, till next Tuesday?
No, it has to be reported out today because it's an early bill.
Madam Chair,
Representative Pearson.
would it not be advisable, since I do not hear a consensus of understanding what is possible, that someone or yourself, Madam Chair, calls the clerk and lays the possibilities before him?
That's exactly what I was about to do. Representative Corson.
Thank you, Madam Chair. I really like this bill and I think it's very important, but I have concerns about the bill that are not fiscally related. For one thing, this bill would add a new paragraph to the Foster Care Children's Bill of Rights, which would state that they have a right to live in an environment that maintains and reflects the child's cultural background and heritage. Especially from being up in the North Country, that is going to be super hard to find. Not only that, but I worry that it would open the state up to lawsuits if we don't have a culturally appropriate foster care. Does that make any sense? I just feel like by changing the Children's Bill of Rights, we're codifying that they should go to a home that reflects their culture. And I'm not sure we have enough of those.
Okay, we can do interim study. Do I hear a motion? Representative Rice. Oh, let me open the hearing on House Bill 1779. Representative Rice, do I hear a motion?
Oh, yeah, we have an amendment.
So point of order, all that discussion was like in the ether, right?
Yep. Okay. Okay, so Representative Scher, do you want to make a motion on,
Technically, I can't make a motion.
oh, you're right, you can't. Does somebody want to make the motion on the amendment, Representative Pearson?
Yes.
What is your motion, sir?
Oh, this is an amendment that we accept. What am I being asked to do? Yeah, okay, we have different opinions here.
That,
Do you
Madam-
want to
Madam Chair?
move it, or do you want to withdraw the amendment for the time being?
Madam Chair, I make a motion that we consider amendment 0590H.
Do I hear a second?
I'll second that, yeah.
Representative Pearson,
Thank you.
do we have further discussion on the amendment? Representative Scher.
Just to state, for clarity's sake, what this amendment proposes to do. It proposes to take out the language that DCYF identified as causing it to cost them money by taking out the word specialized in two places, by making the cultural advocates voluntary. So I think it's a nice first step, and then, you know, I will support the interim study motion when that comes after this amendment is adopted, assuming it is.
Representative Petrino.
Thank you, Madam Chair. So if we adopt this amendment, okay, and we move forward, and assuming potentially ITL on the floor, okay, there's nothing that, from my understanding, precludes an ad hoc committee being formed over the summer, whether it's interim studied,
You're right.
whether it's ITL. This summer, we can still study this bill and introduce legislation next year, regardless of any motion. And I just want to make sure that I understand that.
So the motions that we are looking at right now are OTPA, ITL, or interim study. So do you want some time to discuss it with your caucus? I'd be happy to do that, and I will discuss it with mine. And regardless of what happens here today, Representative Georges, I want you to know that it is the mindset of the Republican caucus to work with you over the summer, whether it be tabled or interim study, to work with you to create a bill that we can get passed. Because this is a very, very, very important subject, and we really, really like the idea of the bill. So I just want you to know that. So yes, we're gonna take a 5-minute break, and then we'll come back for discussion, madam.
which is not our,
You gotta speak up.
I'm worried that I don't trust what's gonna happen on the floor, and I'm worried
Whose
that it's
phone?
going to be politicized
Is that your phone, Mike? Can you turn that off?
to make us, to turn it into something
Thank you. Just one moment. Representative Georges would like to make a statement, and I'm agreeable to that.
Thank you, Madam Chair. I just want to say something because I'm a woman of God. All my work I do because for God, and I believe that. If it's my first time, it was my first year to enter to the state to know all. But if I did this, because I know for the work I do, and I'm here for children and family law. And I believe the first time we talk here, we are here for the best interest of the children. And this bill is for the best interest of the children. All of us, we are parents, we are who we know the best interest of the children. It's not because for my children, because I know my children, they never choose to go to the foster care because I will tell them, you do something, you want to just call the police, they take you away, you're going to go where you know what you're going to do. But there is those children who doesn't have a choice, who suffer. And I think so, any decision we can make it, let's make a decision not because for bipartisan or because who we are or what happened. Let's make a decision because for the children. That can be something can make anyone to feel better or not. It's for the children. Make sure those children suffer and they're lost. They lose everything.
Thank
I
you,
think so, Dr.
Representative. Representative Corzine, did you have something to say?
I did. As we were talking, I just happened to bring up a story which kind of goes along with this bill in that when my husband and I decided to foster and adopt our sons, they're Puerto Rican and they came right from well, they didn't, but their family came right from Puerto Rico. And the first time I was sent down to go meet them, the oldest, Pedro, he refused to get in the car with me because women don't drive. So I wonder, under this bill, would I not be able to drive him? Like, I think the bill is great. I think it has the best of intentions. And I absolutely agree with the underlying premise, but there are things that need to be worked on because he got used to me driving and actually very much approved of me driving him places after a while. Thank you.
Representative Levesque?
I also agree. Like, I support the premise of this bill. I think that, teaching kids about their cultural background, my mom is actually doing it with me, showing me my background, so that way I can teach to my kid, my future kids, and that way I think we all should, learn more about a background, especially kids that are in foster care. They've lost touch of their background and the way that their family wants them to be brought up. I think teaching them about that is really important. I think that we definitely need to look at this more. I think a lot of experts need to come and talk to the committee and give us their opinions so that way we're not like rushing into a bill that that needs to be more thought through, and I definitely support this.
Thank you. Before I accept motions, I don't see anybody in this room that doesn't feel very proud of their cultural background. Because a child cannot live in the home with the biological parents for whatever the reason is, should not mean that that child should not be able to be just as proud of their cultural background and have some connection to it. So again, I agree that this bill is very important, and that's why I want to work on it. I want to get it right. I want to get it so that it's not going to hurt any child. Representative Georges is right. She's correct 100%. This is about the children. So with that said, I will entertain a motion.
Madam Chair, I believe we do have a motion already on the table, and that is the amendment that I moved, and I believe it was seconded.
Okay, in that case, we are going to ask the clerk to call the roll on the amendment 0590H.
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative McMahon.
Yes.
Representative Nelson.
Yes.
Representative Moffett,
Yes.
Representative Corson, yes. Representative Markel,
Yes.
Representative Pedrino,
Yes.
Representative Shear,
Yes.
Representative Levesque,
Yes.
Representative Gregg, Representative Raymond, Representative Georges,
Yes.
Representative Malone,
Yes.
and Chairman DeSimone,
Yes,
15-0.
thank you. Now I will entertain a motion from on the bill as amended. I'll
Madam Chair.
recognize Representative Petrino.
Thank you, Madam Chairwoman. I move interim study.
Second.
Representative Petrino moves interim study. Representative Rice seconds. Do I see any discussion? Representative Gregg.
Thank you, Madam Chair. I think that we all think that this is important. We all are thinking about children in this, and so I think this is the right move for the committee in a spirit of good faith that we all want to work on it and make sure that we're doing what's right and kind of clean up any loopholes or definitions and stuff. And I hope that this would move forward positively. Thank you.
Representative Scher.
Just a brief note, I would encourage the chair and the committee as a whole to get in place a subcommittee as soon as possible so we can talk this through, and if we need to consult with other people, we'll have the time to do that.
Representative Scher, as soon as we get the go-ahead from leadership that we can begin those interim study meetings, absolutely. I would ask Representative Petrino to send me a list of the caucus as to who would like to be involved in that. And I will ask the my caucus to let me know who wants to be involved, and we can get this thing going. Thank you.
Madam Chair, I have a question.
Certainly, your question is?
Okay, my question is, it concerns the Foster Care Oversight Subcommittee, which is part of the Oversight Commission on Children's Services. So I'm wondering how we can get this topic on their agenda so that we can get input from them. I'm not sure of the procedure.
We will just contact Senator Sullivan and get that done. That's a great idea, Representative Petrino. I like that because they can give us a lot of information. Thank you. So the motion on the floor is interim study. Seeing no more discussion, will the clerk call the roll? Representative Pearson, can you shut your...
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative McMahon.
Yes.
Representative Nelson.
Yes.
Representative Moffett,
Yes.
Representative Corson, yes. Representative Markel,
Yes.
Representative Petrino,
Yes.
Representative Scher,
Yes.
Representative Levesque,
Yes.
Representative Gregg, Representative Raymond, Representative Georges,
Yes.
Representative Malone,
Yes.
and Chairman DeSimone,
Yes.
15-0.
Yeah. The vote was unanimous. I will close the hearing on 1779. Actually, I'm going to
But can I move consent, and then if it's not, we'll put it on the regular?
Representative Rice wants to move consent. If we find out from the clerk that it's not able to go on consent, we will not put it on consent. So the clerk can just hold off on checking that off, please. Thank you. Okay.
He hasn't responded yet.
He's busy.
I know.
Poor guy, I know.
I'll let you guys know as soon as I hear.
Caleb, do you know? Is everybody ready? Is the clerk ready for the next bill? No, we have one more bill, 652. Oh, yeah. I will close the hearing on 1779, and I will open the executive hearing on a session on House Bill 652 FN. Representative Pearson, do I hear a motion?
My motion is ITL.
Representative Pearson moves ITL. Representative Nelson seconds. Do I see any hands for discussion? Representative Pearson.
Thank you. This bill was originally voted ITL out of the committee 12-2. The minority recommendation was for interim study. But the bill was sent back to us. And we were encouraged to study it, which I'm sure different ones did. I did at some length. Academically, half of my work has been in the area of history. And I look back to England in the Middle Ages. Law in England under the Anglo-Saxons was very informal, very small and localized. After the Norman conquest of 1066, the French law system came in, which was very structured, very hierarchical, very rigid, with what we today would call criminal court and tort court. However, numbers of people found that they were in situations where the rigidity of those two court systems just didn't fit what was needed. They made appeals to the Chancellor of England, who was usually a priest or a bishop, and out of his knowledge of canon law, which has flexibility in it, and as a parenthesis, I have been asked to be judge in 2 canon law trials, so I'm familiar with that system. It was more flexible. So out of that appeal evolved what was called chancery courts or equity courts, because the cases being brought were quite different. They didn't fit tort. They certainly didn't fit criminal. Their rigidity of what had to be done fit those courts, but not courts of equity. Over the centuries, countries, and in the recent couple of centuries, most states have courts of equity. And I wish to thank Attorney Grant, our committee researcher, for all the various reports she did for me and for me when I chaired the Special Committee on Family Court. There are some issues in family court that need to be addressed. Some of them already have been, and the judiciary has responded. I think we've got a few more, but what will not help is if we dismantle this court of equity called family court. It will put cases into the wrong places following the rules that don't work. So therefore, any attempts to either abolish family court or turn it into counseling where then anything that's decided has to be approved by a superior court just won't work. So for that reason, ITL.
Representative Rice.
Thank you, Madam Chair. So I would just like to say that I have every intent of talking with judges this summer to try to work out the whole evidence problem we're having. Because I think that it's important, but I don't think that dissolving the family court is the way to go. I think that we have over the years made incremental improvements to the family court system when the problems are brought to us. But this is just not the way to go. Thank you.
Representative Gregg.
Thank you, Madam Chair. I would just like to say that I know I've said it a few times, but it's always, every time this gets brought up, I think it's important to talk about any time that the family dissolves and it's not what you thought was going to be when you said your vows, or, you know, you had your kids or whatever, and you have to take it to court because you yourselves can't agree on what happens. It's going to be an incredibly fraught process. It's going to be, you know, nobody's going to be happy because somebody's, you know, judging your parenting all of a sudden, they're judging your money, everything else. And so, you know, with that knowledge, we have to look at the fact that we get a lot of testimony in here from one direction, and we also have it from other directions, and we're required to look at the entire thing. We're also required to look at what due process looks like for people. Yes, we can talk about the evidence and that standard. We have a state where we have more pro se than most other areas. Pro se is a wonderful thing to be able to do. It's also a heavy, heavy responsibility because you have not spent the time, you know, going to school and learning what, you know, evidentiary standards are. And so you're trying to catch up and do that. I think the courts, and we looked into this, have done a pretty good job of trying to give like a how-to manual, you know, when you get there on how to do that. But that doesn't replace years of education and being able to do that. This is a very complicated thing. I also think it's a problem when we look at this in itself is a constitutional court. The family court is a part of it. The Supreme Court is able to make this court. It is the constitutional court. When we start talking about doing things where you take it out of a constitutional court and put it in something unconstitutional, then how do you protect constitutional rights? It's very, very complicated, not easy. I do think that if the system has issues, we fix those issues. We don't burn it all down in something that could be even worse. But unfortunately, we just can't fix family dynamics. When people can't even fix their own family dynamics, the courts are not going to be able to either. It's going to be very complicated. The best thing we can do is make sure that due process is being followed, that we have, you know, regulations that are clearly outlined, and you know, I think that's the best process. So this bill, unfortunately, does not hit the marks that we need to do to really actually protect families in this state.
32 years. I'm concerned about what I keep hearing from people who come before us about judges won't let me present evidence of. And I'm not sure what that means, whether that's a small minority or not, whether it's just a misunderstanding of what the word evidence means. But that said, I'm more than willing to join Representative Rice this summer in talking to judges about that. It's an area that interests me. I will say there is one person present in this hearing room who has suffered through my teaching the law of evidence. So beware.
Representative Nelson.
Thank you, Madam Chair. I just wanted to add too, procedurally, if we combine the courts, priority will be taken by criminal cases, and we already have issues with people thinking that there are delays in family court, and sometimes there are significant delays. But when you add everything together in the mix, the delays and lag times are going to be increased because criminal cases will take priority.
Representative Corzine.
Thank you, Madam Chair. I was one of the 2 dissenting views last time it was up. I think a bill like this is important. I'm very new to all of this, and yet I cannot tell you how many times I've heard about just unjust things happening within family court. For instance, even as far as the evidence, there's there's a mom up in the North Country right now fighting to get her child back. They are accusing her with Munchausen by proxy, and they have written a whole report about to actually be able to defend their stance in keeping this child away from her mother. In the report, it mentions a lot of the child's history and whatnot. A couple of the lines of their report said that, you know, this little girl had a tonsillectomy because her mother chose it, and she always chooses the worst option. This mom actually showed me the paper from the doctor, a signed paper from the doctor saying that he himself recommended the tonsillectomy. I don't know if this mom is innocent or guilty, but I do know that she should have the chance to give that evidence. And that evidence was not allowed in by the judge, even though she begged him. And it's these issues that I see, that it's not right. Many families up in the North Country feel like they're fighting against a system that's supposed to be with them, not against them.
Thank you, Representative. Before I call on Representative Pearson, there's obviously some issues. None of us are blind to that. There's not a person on this committee that is blind to the issues. However, this bill in no way addresses those issues. It doesn't give a viable option. It says in the bill, mediation. Well, if people could go through mediation and it would work, we wouldn't have backlogs in the court. The unfortunate part is the people who are involved in contentious divorces and very contentious child custody or parental rights are the ones that are suffering through all of this. And this bill does not give a viable option, because now you're going to, as Representative Nelson said, be sending these families to Superior Court, and they're going to have to sit amongst the backlog of all the criminal and multiple other cases. This is another one that I would like to talk with the sponsor of the bill and work on better language to bring back something else. So with that said, I'll call on Representative Pearson.
Thank you, Madam Chairwoman. I have been talking with the judges for 3 years. I would like to join, however, Representatives Rice and Scher and anyone else in further conversations. The criminal court judges do not want to be involved in family law cases. It's like asking a foot doctor now to do brain surgery. You can be good at what you're good at. Seldom are you good at multiple things. Also, the question of names of judges that keep coming up. The conversations that I have had, certainly with Supervisory Judge Christo and a few others, have been procedures are now, at my suggestion, they agreed, starting to come up with reviews of judges that are complained against very much more than other judges, with outside people looking at cases to review them to see if there may not be a judge or two who at least needs some remedial education. In other words, the issue you're speaking to, Representative Corzine, is being heard. And for my part, in whatever capacity I may find myself in this, I wish to continue the conversation with the family court people. Thank you, Madam Chair.
Thank you, Representative. Representative Georges.
Thank you, Madam Chair. I'm really agree for what they said to review, because myself, I can say what Representative Buzz say about the evidence about, I've been there myself. I'm ready. Sometimes I think my divorce, I always say myself like I was in Africa, I was over there, that my divorce being like it is, because the judge never liked to see the evidence. They never even follow any law. And I always sometimes I regret a lot, but when I came here, I hear everything what the people say. I can say, but we need to review with the judges. That is something uh, to help the parents, to help everybody, because for the state of New Hampshire, we need to do the things that is right, because they do the things that is not right. Thank you.
Any further discussion? The motion on the floor is ITL. Will the clerk call the roll?
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative McMahon. Yes. Representative Nelson,
Yes.
Representative Moffett,
Yes.
Representative Corson, yes. Representative Markel,
Yes.
Representative Petrino,
Yes.
Representative Scher,
Yes.
Representative Levesque. Yes. Representative Gray,
Yes.
Representative Raymond. Yes. Representative Georges,
Yes.
Representative Malone,
Yes.
and Chairman DeSimone,
Yes.
15-0.
Do I? It has a fiscal note, but
Oh, yeah, it can.
it is. So we will put it, do I hear a motion? Representative Rice moves consent. Do I see any objection? Seeing none, consent it is. I will now close the hearing on House Bill 652. We have plenty of time. If anybody has any topics they would like to discuss between each other, that's fine. However, we can go to lunch and be back by about 1:15, please. Good afternoon. Thank you, everybody, for coming today. Going to open the hearing on House Bill 1376. And I'm going to invite Representative Corzine to introduce her bill.
Thank you, Madam Chair and committee. My name is Lori Corzine, but you all know that because I have the privilege of working with all of you. I want to start the introduction by asking a question. Should the state ever demand that you surrender, deny, or renounce your beliefs just to keep your child? That is the question at the heart of this bill, HB 1376. We all agree that the state can and must step in when there is real abuse, when a child is beaten, starved, or abandoned. But we're crossing a very different line when loving and involved parents are being treated as dangerous simply because they do not believe in the current trends in gender ideology. Across this country, parents in Indiana, New York, Illinois, Montana, and California have seen their custody of their own kids reduced or removed. Not because they injured their child, but because they could not, in good conscience, affirm a new gender identity or agree to a transition plan. We have to be honest about what that is. It's coercion. A state that says you can keep your child only if you repeat our creed and believe as we do is not being tolerant, but coercive. And it relies on a very dangerous idea that disagreement is abuse. HB 1376 draws a line in the sand, and it does two things. First, it says the state cannot take away or restrict parental rights solely because a parent will not affirm the gender identity that conflicts with their child's biological sex. Disagreement is not abuse, and caution is not a crime. The second thing this bill does is it says New Hampshire will not sideline good families from being foster and adoptive parents because of what they believe about sex and gender. We should be recruiting loving families, not purging faithful ones. Just as important as what this bill does do is what it does not do. Number one, it does not change any of our abuse or neglect laws. They are all still fully in effect. If a parent truly abuses or neglects a child, the state can and still should act. The second thing that this bill does not do is it does not tell any family what to believe in their own house. The third thing it does not do is it does not deny anyone's identity or block any services. It simply says that the state may not use the threat of losing their child to force you to surrender your deeply held beliefs. Last July, an almost identical bill was signed into law by Governor Josh Stein. He's a Democrat. He signed this after it moved through the North Carolina House and Senate with bipartisan support.
30 seconds.
In closing, let me ask you the question again. Should the state ever demand that you surrender, deny, or renounce your deeply held beliefs in order to keep your child? We must agree that that must never happen in New Hampshire, and I respectfully ask you to vote ought to pass. I will do my best to answer questions.
Representative Petrino.
Thank you, Madam Chairwoman, and thank you, Representative, for taking my question. So I'm just trying to wrap my head around this legislation, and if you can help me along those lines. First of all, gender affirming care has already been outlawed in New Hampshire. It took effect just last month. Conversion therapy also is currently outlawed in New Hampshire. So it seems to me that this legislation is focusing exclusively on parents and whether or not they're going to affirm their child being LGBTQ and so forth. So now, from my understanding, it's never been an issue in the past there have been many parents who have loved and affirmed their children and others who haven't. So I'm wondering if this is really a solution to a problem that really doesn't exist, or is this giving cover to those parents who do not recognize the stress and the turmoil that they are dealing with? And even in some instances, there have been families who have thrown their children out of the house. Very, very large group of unhoused children from the LGBTQ plus community. So again, basically two parts. Is this basically a solution to a problem that doesn't exist because it hasn't been an issue in the past? Or does this give cover to those parents who just don't want to accept their children for who they are?
So let me try to answer that, and I'll answer it in two parts. Your first question has to, is this trying to find a problem almost? The fact is that this is happening throughout our country. New York, Illinois, Montana, California, they are removing custody from parents solely because they don't subscribe to the gender ideology of today. Parents are losing their kids because of this, and sometimes it'll take a year and a half before that parent is found to be completely fit, admittedly fit, and they just lost a year and a half with their child. The second part of that was, could you remind me, sir?
To give cover to those parents who do not support their children.
Sure. So it's not necessarily that it's giving cover. This bill doesn't tell parents how they should feel or how they should think or how they should act. This bill is specifically about telling the state. This is about putting reins on the state, not on parents, not on families. This is simply saying that if the only problem with a family is that the parents are not agreeing with the child, that's not a real problem, because disagreement has been between children and families since the beginning of time. That's all it's doing. This is legislation for the state, not the family.
Thank you. May I have a follow-up, Madam Chairwoman?
Follow up?
Thank you very much. So I think you would agree that the primary duty and responsibility of parents is to take care of the welfare of their child. And so when a child is sick, you take them to the doctor and so forth. If a child is undergoing severe emotional turmoil, stress, and so forth, wouldn't it be incumbent upon the parent to recognize that their child is having concerns? Again, gender affirming care has already been outlawed, and you can't send your kid to conversion therapy because that too is outlawed. But at an absolute minimum, recognizing that, wow, my kid is going through a really hard time, wouldn't you agree that they have to address that, taking the kid to counseling? And if they don't, would that be considered abusive?
Thank you for the question. So if your child is going through a mental health crisis, it is absolutely imperative to get that child help. Absolutely. But I feel like most mental health crises, they span biological, psychological, social, and sometimes spiritual issues. It combines all of that. It's kind of a reductionist view to believe that just the affirmation model is going to help that child, because in truth, it's going to take a lot of different aspects to get that child. Of course, the parents should do what they can to help their child through this. All this bill is saying is that the state cannot take the child from parents simply over an agreement of gender ideology.
May I just have a clarification on the answer? I just need a clarification on the answer.
Sure.
Okay, so I just want to make sure that I understand that if a child is undergoing tremendous emotional stress, that it is incumbent upon the parent to take that child to counseling, to see a psychologist, to address the issue. Again, not gender affirming care, not conversion therapy, but recognizing my kid is maybe suicidal. And if I don't take my kid to talk this out with somebody, the parent would be considered abusive. That may be an abusive home. Would you at least agree to that minimum standard?
So I would absolutely agree that I would take my child to a psychologist of my choosing. I would absolutely agree with that. But we do live in America, and I don't want to force another family to do something that is not something they care to do. Absolutely, I would take my child to go be seen. If a child is suicidal, that's a real medical emergency, and that child should absolutely be seen. But that's not what this legislation does.
Representative Gregg.
Thank you, Madam Chair. Do you differentiate between it says child, does it differentiate between like a 5-year-old versus a 17-year-old, or are you treating those the same as far as their ability to make their decisions?
I would treat those the same.
Okay.
And as a matter of fact, even last week, the plastic surgeons have come out and said that we need to slow down on transition surgeries. And they said they will not do any until a child's 19. So I think that until a child is 18, that parent, especially if they're a loving and fit parent, has every right to help their child through difficult times without being forced to do so by a state.
Thank you. Follow up.
Follow up?
Thank you. So, Court, you touted the North Carolina bill, which your language is similar to, but you've left out one very interesting piece. So there's what is left out of this is, for purposes of this subdivision, a parent raising a child consistent with the child's biological sex does not constitute serious mental injury. You only cover physical. Is there a reason why you chose to leave out the mental injury part?
So there's no reason why I chose to leave that out. I am working with someone who could probably answer that a little bit better than I can. I am super nervous, so I'm trying to do my best, but Lance will be able to answer that.
You're doing great. It's a hot seat.
Thank you.
Representative Scher.
Thank you, Madam Chair. Thank you for taking my question. Here's my concern. You've been talking about this bill protects parents from having their children taken away. As I read it, it does more than that. It says if I am working for DCYF and I appreciate that this 15-year-old is struggling with their gender identity, right? This bill says that they can be placed. It would be wrong, it would be illegal for them to not place that person with a set of parents who believed in raising them according to their biological gender. That's how I read this. That
Could you repeat that? I'm sorry.
all right. So we have a 15-year-old.
Yes.
Who is struggling with their gender identity and has confusion and issues and is uncertain about it. This bill says that DCYF cannot say, I'm going to place this person not with this couple because they don't believe in gender identity confusion. That's what this bill says in paragraphs 1A, 1B, and 3(1)B.
So with all due respect, you may be reading it wrong. This bill is specifically about, can DCYF come into a house, a fit and loving house? These parents are providing clothing, shelter, a roof over their head, and doing it in a loving manner. Can the state then step in and remove the child from the home?
I think we differ in how we read the bill, because I read the bill as saying when an agency is considering whether to
Representative Scher, we're not cross-examining.
I want to see if we can find agreement on what the bill says.
Okay, ask your question. Go ahead.
That DCYF cannot evaluate a set of parents for a foster care or adoption placement based on the child needing an affirming gender confusion placement.
So once again, I believe that the affirmation model is a reductionist view on what these kids may be going through. I believe these kids should be taken to get all the assessments needed, But I don't think the first thing we should jump to is that the parents are unqualified to care for this child.
Thank you.
Representative Raymond.
Thank you, Madam Chairwoman, and thank you for taking my question. I have two questions, one about each of the two parts of the bill.
You can ask your first question and then I'll give you a follow-up.
Thank you very much.
You're welcome.
So the first question is about the first part of the bill where it says that abused child shall not include. And I'm curious whether or not you can point to a part of the current RSA 169C that would allow the removal of a child based on the parents declining services for gender identity.
So as it happens, in a lot of the states where this is
In New
happening,
Hampshire.
in New Hampshire, I have not heard of any cases where it happened yet, but that's why this piece of legislation is important.
So I want to zone in on New Hampshire's law.
Sure.
Where in New Hampshire's law now would give DCYF the authority to remove a child when a parent says, no, I'm not taking this voluntary medical intervention?
Thank you for that question. So there are some who believe so much in this ideology that they would call DCYF specifically and just because of a disagreement and not necessarily abuse or neglect.
Right, people can call DCYF whenever they want, but where in our statute does it give DCYF the authority?
Is
to
that your
act?
follow-up?
My follow-up is on foster care.
Okay. So you
So
need
I'm-
to ask for another follow-up.
Can I have another follow-up, please?
Yes, you may.
Thank you. I'm going to let this one go because it's not in the statute. Regarding the foster care piece, I'm concerned about line, on page 2, line A and B. Currently, our foster child bill of rights says that on item V, item 5, says that the child has a right to have their identity respected in their foster parent placement. That's in current statute. So I'm curious about the parents' rights when it comes to their child in foster placement. So if you have biological parents whose trans or gay child has been removed because of other issues that are not related to the transness or the gayness, maybe there was neglect, maybe the parent was incarcerated, maybe they had to go to the hospital, there was no one else. Does that parent lose the right to insist that their child continue to have their identity be respected while they're in foster care? Or does this bill give the foster parents the right to make those decisions for someone else's child?
This bill does not give foster parents the right to do anything that they are not allowed to do right now.
So follow-up.
Follow-up.
So in this example, you have a trans child who's been put into foster care, unrelated to the transness. The parent's expectation is that the foster parents continue to bring the child to get whatever services that they are already getting to align with their gender identity. However, the foster parents say, I have the right to raise this child in my home now, consistent with their birth sex, because I don't believe that transness is a thing. So whose right wins?
Well, the parents' right should win. I mean, again, this bill does not give foster parents any more rights than they have right now.
I would love to have an attorney weigh in on that at some point.
Representative Nelson.
Thank you, Madam Chair, and thank you for taking my call. I do that all the time. I'm sorry.
I always
Thank you
wanted
for
to be on the radio.
taking my question. I guess I wanted to win those tickets to the. Thank you for taking my question. Isn't it true that in general, when DCYF is placing children with foster families, they do try to match them up where they would be the most comfortable? So if there is that mindset of the potential foster family that would not gel well with a child who has a different gender identity than their biological one, isn't it true that usually they wouldn't be paired up with that foster family, just like in other circumstances?
Thank you for that question. Yes, that's absolutely true. And nothing in this bill changes that. DCYF will always seek to try to put that child into his or her most comfortable situation.
Representative Gregg.
Thank you, Madam Chair, and thank you. I know this is a lot of questions, and this is tough. It's a tough subject, though. So, are you familiar with Wisconsin versus Yoder in the Supreme Court?
I
Sorry.
actually believe I am.
It's on religious freedom and parenting.
No, I do not have that.
Okay, well, in that case, the court said that Amish parents could limit education because there was no evidence of harm. But even there, the court said parental rights have limitations with children's health and safety is at risk. So Section 2 on your bill has no such limit. So I just wondered why the belief in biological sex would have more protection than constitutionally protected religious freedom.
So biological sex is the only sex we can point to and objectively see, touch, feel, hear. You can do a blood test for biological sex. Biological sex does not change.
Any further questions? Representative Raymond.
Thank you. I just want to bring your attention to page 2, line 3, where it says the department or licensed child placing agency shall not consider an adoptive parent's refusal, unwillingness, or lack of support for enabling the child to engage in gender transition as a basement burn assessment that the home is an unsuitable home for the minor child. And I'm curious how that meshes with the argument that the child would be allowed to continue with their transition, once they're in placement.
So
And that you know what I mean? You said DCYF always matches, but in this case, it says they can't consider that.
thank you for the question. So if DCYF has to step in and take a child, remove a child from his or her home, which is traumatic in and of itself, they will seek the best placement for that child. If there's not one available, they may have to put a child where it's not a perfect situation. Especially here in New Hampshire, we lack resources. We lack foster homes. Do you want that child in a group home as opposed? This bill does nothing to tell DCYF where to place a child.
One last follow-up. Thank you for your indulgence. So right now, adolescents in DCYF custody have the right to say no to adoptive and foster homes when they feel like it is not a good match for them or they don't feel safe. Would this bill impact that ability? Because again, here on page 2, it says shall not consider with that thing. Does that override the child's right of refusal?
So this bill does nothing to override a child's right.
Thank you, Madam Chairman, and thank you, Representative Corson, for taking my call. I'm sorry, now I've done it. I'm sorry.
Another
long-time question, listener, Caller, your first time caller. Yes, I'm sorry.
Clearly
Please
it's
forgive me. Every once in a while, you have one of those days. And one of the things I've noticed here, and by the way, first of all, let me commend you by your case sites with Meyer v. Nebraska, Pierce versus Society of Sisters, and Troxel v. Granville. They do establish key points. My concerns are with line 22 on page 2, best interest of child, and how this is going to amend RSA 461A by inserting a paragraph here. This goes to parental rights and responsibilities. Assuming, for example, where well-settled case law is in Inree Berg, where the parents patriae doctrine indicates that states have a competing interest in the well-being of their children. Why and why under that basis, where there is going to be a family which is not intact, because most of the other things you have here deal basically with intact families, with the exception of Troxel, which dealt with a family that wasn't intact, and that was grandparents' rights. So, that being the case, why would you not want to restrict a court from considering a factor that restrict that from the best interests of the child? Under how would you reconcile that with the holding of Berg?
So this bill isn't, again, this bill is not telling a child
Mhm.
what to do, what to think, how to present. This bill is specifically limiting the state and its powers over fit, intact, good, loving families.
May I ask a follow-up question?
Yes, follow up?
Thank you. Would this in any way restrict a parent's arguments in the event of either a divorce where there are minor children or a parenting petition where you don't have an intact family? Would this restrict a parent's ability to be able to advocate for the best interests of their child?
So this bill does not mandate how a court decides custody. This bill won't take that into consideration.
Okay, thank you.
Representative Scher.
Thank you, Madam Chair. And again, thank you for taking my questions. I know there's a lot of these questions. I'm going to follow up on what Representative Markle, I was going to say Attorney Markle, Representative Attorney Markle
Okay.
Was asking about. In that lines 24 through 30, we're talking about, one, a family that's not intact. And as I read those lines, it says if one parent wants to raise a child only based on their biological identity, and another parent is willing to take a different approach, the court, is it the case that 24 through 30 says the court cannot take into consideration the issue of biological identity in deciding which parent the child should go with?
Correct.
Thank you.
Representative Georges.
Thank you, Madam Chair. Thank you for taking my question. It's not really a question, but I just want, for my understanding, I want to know for this bill, is protect, the state going to protect a child or is protect the parent?
The state will be protecting the child by protecting their relationship with their parents. Because if their parents are good and loving and caring, one disagreement shouldn't force separation.
Thank you. Seeing no further questions, thank you very much.
Thank you.
The next pink card I have is Representative Catherine Prudhomme O'Brien. Thank you for visiting with us.
Thank you.
You'll have 3 minutes after you introduce yourself.
Okay, I will read quickly. I'm Catherine Prudhomme O'Brien, Rockingham 13, Derry. Last year, I learned that Lydia and Heath Marvin of Woburn, Massachusetts lost their foster care license because they refused to sign a pledge affirming gender identity over biological sex. Although it happened in another state, it affected me personally, and it is why I co-sponsored this bill. As a teenager in foster care, Woburn was one of the towns my social worker searched for a placement so I could stay in my regional high school. My only concern at the time was safety. Foster youth evaluate adults differently than policymakers do. We ask one question: can this person protect me? I didn't need an ideological agreement. I needed peace, stability, and adults committed to my well-being. People willing to foster children are a rare and precious resource. We should not be turning them away lightly. This bill is about protecting that resource while honoring the New Hampshire Constitution. Article 4 of our Bill of Rights protects the unalienable rights of conscience.
Article 5 guarantees religious liberty. Article 6 affirms equality under the law. Article 22 protects free speech, and Article 2 recognizes that all government power is derived from the people and exists to serve their protection and benefit. Together, these provisions create a clear principle. The state cannot compel belief as a condition of civic participation. Government may regulate conduct to protect children, but it cannot require caregivers to surrender conscience or affirm statements they believe to be false. That is compelled speech. Our Constitution does not permit ideological tests for public service. This protection applies to people motivated by faith and to those motivated by scientific concern. The science around medical treatment for gender dysphoria in minors remains unsettled, and reasonable adults can disagree in good faith. In an area of evolving evidence, the Constitution protects the right to question without fear of exclusion. Disagreement is not abuse. It is part of responsible guardianship. When the state narrows the pool of foster caregivers through ideological requirements, children pay the price. Fewer safe homes mean fewer options for youth in crisis. I speak as someone who once needed that safe home and never found it. I know how rare willing caregivers are, and we should be expanding the circle of protection around vulnerable children, not shrinking it.
30 seconds.
This bill affirms a simple constitutional truth. The state may not. I'm going to skip ahead then to something I wanted to say. On February 3rd, the American Society of Plastic Surgeons recommended all gender-related surgeries be delayed until at least 19 years old. Due to recent publications reporting a very low certainty of evidence regarding mental health outcomes and emerging concerns of long-term harms and the irreversible nature of surgical intervention. They were joined by the American Medical Association a few days later with a similar message. In this environment, of course, loving parents, guardians, and foster parents are right to be worried. It's up to us to protect them. For the sake of children who need safe homes and for the integrity of our Constitution, I respectfully ask that you vote to pass on this bill.
Thank you. Questions for the representative? Representative Petrino.
Thank you, Madam Chairwoman, and thank you, Representative, for taking my question. I want to again make the point that gender affirming care is not the issue because it's already outlawed here in New Hampshire. So my question then is, if a child, a minor child, is struggling with their gender identity, and the state wants to place that child in a home that affirms that, just affirms it, would that be considered a safe place for that child?
I think we went over this a little bit before, and that is that there is an attempt to place children with homes that are places where they would be comfortable, where what they want, what their biological parents want, are in alignment.
Representative Scher.
Thank you, Madam Chair, and thank you for taking my question. Did I hear you right in essentially saying that a child's 15-year-old's confusion about their gender identity is a matter of ideology?
It can be, yes.
Is it?
Well, you'd have to ask, why is it that this was something that was going on for a long time, and yet now the American Medical Association is saying, let's put the brakes on it. The American Society of Plastic Surgeons is saying the same thing. When in the United Kingdom there was a child pediatric gender clinic, that was closed, and that was one of the reasons that was cited for why they closed it. It was because that there was ideology that was keeping people from being able to ask intelligent questions about the care of children. The medical staff there said that they felt pressured to not ask the kind of questions that they would ask about every other medical procedure.
Follow up?
Follow up.
I'm not asking about medical staff. I'm not asking about associations of doctors or plastic surgeons. Is it an ideological statement on the part of a child who is engaged in thinking through their gender identity, in struggling with their gender identity, and having certain feelings? Is that an ideological statement on the part of that child?
It can be. That is my opinion.
Thank you.
Representative Gray.
Thank you, Madam Chair, and thank you for taking my question. Knowing that that parents have constitutional rights and so do children. Is this weighing, how does this fall in the balance? Does this make parental rights over children's constitutional rights?
Well, children are being guided by the adults and the caregivers. And this doesn't just apply to foster parents, this would apply to parents as well. And parents do have the right to guide their children in the way they find best.
Representative Petrino.
Thank you very much, Madam Chairwoman. And thank you again for taking my question. So I've asked this before. If a child is struggling emotionally, they're dealing with questions regarding their gender identity, wouldn't it be incumbent upon a caring, loving parent to do right by their child in terms of acknowledging the child's concern, bringing them to professionals to talk it out? And if they don't do that, would they be neglectful and thus not qualified to be parents?
Mm-hmm. I think we're entering a new phase here as a society on how we think about these things. I think it's a pretty serious thing that a woman in New York just won a lawsuit against the surgeon and the psychiatrist who gave the green light on surgery for her when she was 16 years old. And now she's 22 years old and she's had her breast removed. And she just won a $2 million lawsuit. In that environment, I would think that parents would be correct to be cautious about this. Whereas in the past, they were told something different. They were told that no matter what, they have to affirm or their children will commit suicide. Things are different now. We're learning more about this. And I think that's a good thing. Science is a good thing. I believe in science.
Quick follow-up on that, please. I don't think my
Follow-up.
question was answered. Okay, so once again, gender-affirming care is illegal in the state of New Hampshire. So we're not talking about anybody's genitals being removed. Okay? The question is the emotional well-being of the child, to acknowledge that this child is struggling. And I can't get my kid gender-affirming care, and I can't even take my kid to get conversion therapy, but at a minimum, I need to address this. And a good parent would address this. I want to talk about the emotional part.
Okay, I want to make my opinion known on that, and that would be that a good parent has the right to think of all of the science involved here and to think about this and to think about what is the best course of action with their child. We're learning that a lot of people, females that go in saying that they have gender dysphoria, a lot of them are autistic. That should be a first step. That should be best practice for any medical professional dealing with this. Those would be the areas that they could explore. They could also explore if their child has been sexually abused. That's another issue that is coming up in very high rates with children with gender dysphoria. There are a lot of ways you could help this child that don't necessarily mean suddenly 100% affirming.
Representative Nelson.
Thank you, Madam Chair, and thank you for taking my question, Representative. Question this time, yeah, thank you. Could it be true that both things could be happening at the same time? That you're disagreeing with something about the child that is in your care, yet you see that they need help, and so you would take them for help?
Yes, absolutely. Both things can be true, that you are very concerned about these issues and that you want to help your child or the child in your care. But you also want to be cautious about the way things have been done in the past. And now you're learning about the recommendations by the American Medical Association. And you may say, I'm going to dig into this a little bit more and find out more about why they said that, about why they're saying that the long-term outcomes are not necessarily positive.
Representative Gray.
Thank you, Madam Chair, and thank you for taking my question. So I'm sure you heard me talk about the religion piece earlier. So once we create categorical exemptions from child welfare laws for one belief system, like where does this stop? So if we can't consider harm related to gender, can we consider harm related to other potential things like religion or anything else? Where is this slope? Because we really do walk a slippery line here between children's constitutional rights and parental constitutional rights.
Sure. When you turn 18 years old and you age out of the system, you do not have to go to church anymore with the family member who may insist that you attend church with them. You get to grow up intact. With some of these medical procedures, that may not be the case. You may grow up to be sterile without realizing that you would be sterile. You may grow up to be unable to have an orgasm without realizing that that's the path you were going down when you started taking these hormones and some of these medical treatments. And the way to get on that path is social transition. And so, of course, parents may be concerned about this and may say, let's slow down. I don't think that this is the best way to go. And if a parent does do that, I think it's appropriate for us to enshrine in law that that is not abuse.
Representative Chair.
Thank you, Madam Chair. And again, thank you for taking all these questions. I'm going to go back to Representative Petrino's question, the circumstance where, again, a 14, a 15-year-old is in emotional turmoil over their gender identity. And their parents do not choose explicitly not to recognize that. Are you aware that the science says that there is now an increased risk of that child engaging in one of 4 different behaviors: cutting, attempted suicide, running away, and deepening any emotional distress into a significant mental health concern? Are you aware of that science?
I would go a little slow on that science, since we're finding out that the long-term benefits are not always what is gained. I mean, there has to be a reason why these gender clinics are closing all over the country, and why Jamie Reed, when she worked as a case manager at a clinic like this in Missouri, why she thought she was going down the right path pursuing those, and then became alarmed at the problems that the patients at her clinic were having, and that they weren't achieving those outcomes that you are concerned about.
Follow up?
Follow-up.
So I take your answer to mean that you're not aware of that.
I am aware. I am aware of those things. I was a child in crisis. I am aware.
Representative Raymond.
Thank you. I keep going back to the same question. Is there anything currently in our child protective statute here in New Hampshire that would allow DCYF under our laws to remove a child because the parent says, no, I'm not participating in your transition?
Thank you for that question. I remember the long conversations that I constantly had with my social worker trying to find a safe placement, which didn't happen, which was not happening. And the questions she was asking me, trying to make sure I had a comfortable fit.
Before that.
No, I know where you're.
She's answering.
And I know that my social worker was, and my social workers were wonderful people working very hard to find a good fit within the conditions that they had. And I think that's what will continue. But there's a tremendous amount of privacy involved in these cases, meaning that there's a lot we do not know, and there's a lot of judgment that the social workers will be using based, to make a placement. And there's a lot we don't know, and I think that in these current conditions, as we are learning more as a society about what is healthy for children, and we're learning more about why these medical societies are advising against earlier interventions, I think it's a good idea to keep that in mind and to protect parents who want to pursue the science and what is shown to be medically positive for their children.
Just to follow up on that, my question is not about placement of the kids. My question is there anything in state law now that would allow DCYF to file a case in court and win to take a child from loving parents simply because the parent said no to gender transitioning?
I don't know if it would be phrased in that way. I think that because of what we're seeing in other states, it was concerning. And it was very concerning to me about what happened to this family in Massachusetts who didn't even address this issue at all with any of the children that they were fostering, because the children they were fostering were infants. So it didn't even come up. But the moment they were asked about whether or not they would affirm or not, they were delicensed.
One more question. Representative Petrino.
Thank you, Madam Chairwoman. Thank you, Representative, again for taking one of my questions. I just wanted to know, do you know of any instances where here in the state of New Hampshire, a child has been removed from their parents because the parents did not affirm their child's gender identity? From what I'm aware of, and correct me if my perceptions are incorrect, it's never been an issue. Again, parents can love and support their child accordingly or not. And many of the homeless youth that are out there are kids who have been kicked out of their homes over this issue. Very large percentage of LGBTQ plus children are homeless. So again, I'm not sure if this bill really addresses anything that has been an issue here in New Hampshire. Can you speak to that? Do you know of any children that have actually been removed from the home because mom and dad did not acknowledge the child's gender identity?
I talked earlier about privacy issues, and unless a parent wants to discuss that openly and in public, that is not going to be public knowledge. And I think a lot of parents, at least the parents that I've spoken to that do have children that are transgendered, they are not in that headspace because they don't want to make things worse. They want their child to get healthy. They want to stay in their child's life and get their kid healthy. Children in crisis are kicked out of the house for a lot of reasons. They can get kicked out of the house for observing that they're being abused and their parent doesn't want them to talk about that. That's a big reason to get kicked out of the house. There's all kinds of reasons to get kicked out of the house.
Thank you very much for your testimony. I really appreciate all the time and the time you took to answer the questions to the best of your knowledge. I appreciate that. Thank you.
Thank you very much, and I appreciate all the questions. Thank you.
Next, I'd call on Representative Lisa Mazer. Welcome, Representative Mazer. You'll have 3 minutes.
Yes, thank you. I'll be less than that. Thank you. Yes, for the record, my name is Lisa Mazer. I am a state representative for Hillsborough District 44, the towns of Goffstown and Ware. Thank you, Madam Chair and members of the committee. I sit here and rise to support this bill because it provides much needed clarity in our laws by clearly stating what should not constitute abuse, neglect, or endangerment of a child. This legislation does not restrict care, love, or appropriate medical or mental health support for children. What it does is provide clarity in statute that raising a child consistent with their biological sex, including how parents speak to and guide their children, cannot alone be used as grounds to remove a child from a home, terminate parental rights, or deny adoption opportunities. Parents across New Hampshire deserve confidence that they will not face government intervention simply for exercising their role as parents. This bill protects families, supports parental authority, and maintains that the state should only step in when a child is truly at risk of harm. For these reasons, I respectfully urge the committee to support this legislation. Thank you.
Thank you, Representative. Any questions for the representative? Seeing none, thank you very much.
Thank you.
Next, I'll call Representative Timothy Horrigan.
Thank you very much. I'm Representative Timothy Horgan from the Stratford County District 10, which is the town of Durham. And probably like every other community, there are a number of trans people of various ages living in Durham. And this bill is not good for trans people or for any people. First of all, the timing is bad, just given basically, well, I don't know whether paranoia is the right word, but there's been a lot of fear spread about the trans community far out of proportion to like any harm they might pose to anyone else, which is basically they're no more harmful than any other human being. So I think the timing is bad for this bill. I'm also opposed to it on principle. At least two things I might mention about how it's drafted. And first of all, as far as I can tell, this actually was drafted here in New Hampshire. I haven't been able to find, I did a few quick Google searches, haven't found any instances where identical wording turns up in other states. So this is a homegrown bill, as far as I can tell, but it's not necessary. And there's two big problems with how it's drafted, which wouldn't be enough to get my support for it. But if you fix them, one of this definition of abused child, that seems to create a loophole actually for any child who's being raised by their parent or guardian inconsistent with their quote unquote biological sex. So which is about 99% of the population is not trans. So like it seems to create a loophole for abusive parents. They could say like, well, they could probably claim that this paragraph lets them off the hook if they're trying to. So that's one problem. There's also like a lot of these bills, there's no definition of biological sex, and I know that seems like a simple concept when you first think about it, and we all remember the biology, I guess it's 8th grade biology, or where you learn about the XX and XY chromosomes, but that's a much more, gender and sex is a much more complicated issue than that. And also, I'm not sure whether the dichotomy between gender identity and biological sex is a valid one, since the brain is the largest organ in the human body. Our beliefs about who we are just as much a part of our biology as anything else about it. So I'm not sure. Whether biological sex really is different from your gender identity, and probably the gender identity has a lot more to do with like how you live your life. So I would just say, I'd say probably the best thing to do is not pass this bill. I mean, I might be a little bit more sympathetic if they took out all the references to biological sex and talk about gender identity, because certainly that's not good if a child identifies as one gender and their parents are sitting there the opposite. So I would just urge you to find this bill inexpedient to legislate, or find some other reason not to pass it. And I'd be happy to take any questions if you want to. But
Thank you, Representative.
thank
Any
you.
questions?
Okay.
Seeing none, thank
Anyway,
you very much.
just say no to this bill. Thank you.
The next card I have is for Lance Kinzer. Thank you for coming today, Mr. Kinzer. As soon as you introduce yourself, you'll have 3 minutes. Turn on your
excuse me.
video.
My name is Lance Kinzer. I'm here on behalf of First Amendment Partnership. Much of what I had in prepared remarks has been discussed, and so I'm just going to try to see if I can go through and answer a few of the questions that were raised, at least to the best of my ability at the time that I have. First of all, I would say that it's absolutely the case that there's no affirmative language in the New Hampshire Code that's being stricken by this language. In other words, nothing in the code that specifically says Child Protective Services can remove a child based upon the parent being non-affirming. However, the definition of abused child in the current code is quite similar to definitions that have been used in other states where there has been action to remove children, not for anything that meets a traditional understanding of physical or mental or emotional abuse, but rather simply for, as someone described it previously, a disagreement over a relatively fraught and contentious issue of how best to deal with and how best to care for a child who's experiencing some gender confusion, maybe gender dysphoria. I would note in that regard, in response to one question, abused child, the definition in the code includes psychological injury. So the feeling was that, unlike the North Carolina bill, which I wasn't involved in drafting, I didn't testify in favor of, but it was a reference point, certainly, in working on this bill with legislators here. The feeling was that the definition, because abused child includes psychological injury, that we were including that by defining abused child in the way that we have here. There have been some good questions asked about the fact that we already have a circumstance where gender affirming care has been banned and where conversion of therapy has been banned. And I do want to indicate that this bill does not interact in any way to alter the underlying law in New Hampshire as to either of those issues. What it does make clear, especially in the context of social transitioning, is that merely doing things like referring to a child consistent with pronouns that match their biological sex, that can't be abuse. So it is a defining of abuse. And then with respect to this idea of mental health decisions, and particularly the issue of wouldn't a good parent seek care for their child if they were in a mental health crisis? And I guess my first response to that is to say, of course, that's an extremely fact-specific question. And so determining whether it's wise or prudent is different than saying that there's actually criminal abuse or neglect or civil abuse and neglect or a crime. The final thing I want to note is that the purpose of the foster section, that merely talks about the fact that raising consistent or unwilling to support gender identity doesn't constitute endangerment. If you look at how endangerment works in the statute, that doesn't relate to how placement decisions are made or any of those questions. It's a very narrow portion of the statute that just says if you engage in child endangerment, you're basically disqualified from being a licensee. And the point is to say that we don't want to say you can't get licensed at all to provide these services in New Hampshire if you have a particular view on gender identity. I didn't get to near as many of the questions that I wanted to, but I've used my time, so thank you.
Maybe somebody can ask you those questions. Thank you for your testimony.
Thank you.
Representative Scher.
Thank you, Madam Chair, and thank you for being here and taking my questions. As I read, do you have a copy of the bill in front of you?
I do, yes, sir.
Look at page 2, the section identified as 1-A, page lines 3 through 6.
Yes.
As I read that, a licensed child placing agency shall not consider an adoptive parent's refusal, unwillingness, etc., or lack of support for enabling the child to engage in gender transition as a basis for an assessment that the adoptive home is unsuitable. As I read that, a child placing agency like DCYF cannot reject a potential foster home or adoptive home because for a child who is in gender confusion or experiencing gender dysphoria, simply because that home says, those parents say, we will raise this child according to biological sex.
Yeah, so what I would say is that 4, so at the top of page 2, relates to adoption, and then section 5 relates to foster care. And they are somewhat different in terms of the way that those are drafted. Going to your specific question around adoption, the real concern, I think the intent of the bill is to try to make sure that when you've got a situation where someone is adopting out of the foster system, which is really where this primarily comes into play, oftentimes these are existing foster parents who are doing the adoption, but I suppose not always, and states differ, that a home would not be precluded from consideration, in other words, viewed unsuitable and so not considered for adoption based upon exactly the things that are listed here. I will say, and I'd be open to working with the committee or would invite the committee's work if there's a feeling that additional language that would make clear things like in making a placement, you could take into account, make it clear because it's not intended to prohibit the department from saying, let's look at the religious background of the child when we're making a determination as to where it's best to place that. And we can compare that perhaps with the religious background of the family that's doing the adopting, or we could look at the child's views on issues of, say, marriage and family and sexuality, and and compare that to the adoptive family. What the real intent is to say that we're not going to say that a particular adoptive family is per se unsuitable or ineligible to adopt, and that's really the issue that's arisen in a number of other states. You might note it's had a fair amount of media attention here recently on the foster side with a family that was hoping to foster in order to adopt. In Massachusetts, they had a policy in place that ultimately resulted in some litigation where they were saying, and a number of other states have done this, Vermont, there's active litigation there. They've said that you're not eligible to participate in the foster system at all. You can't be licensed to foster. You can't be considered for adoption if you're not sufficiently affirming. And as you can imagine, there's been a fair amount of litigation on that, in part in response to some litigation. Massachusetts changed their policy, but the real intent, and if I need to do better, if others need to do better, to make it clear to say that by including these affirmations, we're not intending to say that other factors can be considered, then I'd be happy to work on that, but that's the intent of those sections.
Thank you. Follow up?
Follow up?
Switch topics. Is it your understanding that unrecognized gender dysphoria or gender confusion, unrecognized by the parents in the family setting, can increase the chances of cutting, of potential attempted suicides, of runaways, or significant intensification of mental health issues?
Well, I do know this. I know that there's a lot of those studies are out there, that many of them, especially around the issue of suicide, are contested, especially the issue of whether the increase in suicidal ideation actually relates to an increase in actual suicide attempts. And there's a fair amount of literature out there about that. But I think no one would deny that, given the issues that just come with, say, gender dysphoria, for example, if you have that actual diagnosis, and the significant comorbidities that often attach to that diagnosis, that children in these circumstances are often having a significant range of mental health issues. So I would definitely concede that, although noting that there's a fair amount of contention as to some of the particular studies that you've referenced.
Thank you.
Representative Georges?
Thank you, Madam Chair. Thank you for taking my question. I just have one question again, the same. I just want to know for you with this bill, are you protect a child or you protect the parent?
Well, the intent is definitely to protect both. The focus of the bill is limiting the power of the state in some very narrowly drawn, from my perspective, areas to say that particular type of conduct or action by a parent constitutes abuse, either in a civil context where the possibility is the removal of a child, in a criminal context, we haven't talked much about that section of the bill, or and there was a question about this earlier, or in the context of a custody dispute where one party may be affirming and the other may not be affirming. And so our belief, given the heart of the bill, is that by protecting parents in these areas, we preserve the integrity of families and we protect children as well. Of course, it's a policy judgment for this committee to make as to whether we've struck the right balance, but that's absolutely the intent of the bill, to protect parents and to protect children, and in doing so, to protect families.
Thank you.
Thank you. Representative Gregg?
Thank you, Madam Chair, and thank you for taking my question. So for every other special need, whether it be development, medical, behavioral, we assess whether families can meet the needs of the child. Why should gender-related needs be the one exception?
I think that this bill is a response to, I think, a well-founded concern that in each of these contexts in states across the country, that absent better, more specific guidance from the legislature, really devastating mistakes get made by those within the Child Protective Services world, by prosecutors, by others who have the ability to really impact the lives of so many people, children and parents. And that in a lot of these other instances, of course, there's almost nothing more difficult to do than to assess whether a particular family, let's say an intact biological family, has engaged in conduct that is of such harm to a child that it's better for them to be removed. And I recognize, of course, that decision makers have to make those difficult decisions based upon the best information that they have in a variety of contexts. But we simply think it's appropriate in this particular instance because of the cases of abuse from our perspective of laws designed to protect children in other states, just to make it clear, not that parents who disagree on this issue, who believe that they should raise consistent with biological children, have some unfettered right to then use that as an excuse to do anything that they want to do that would typically be viewed as abuse, but rather that within some relatively narrow parameters as set forth in this bill, that we're simply going to exclude upfront the notion that using a child's pronouns or that comport with their biological sex or seeking lawful mental health assistance for them that's consistent with their biological sex, we're simply going to say as a matter of law at the beginning of that process, while other things may be abuse, that is not abuse.
Follow up.
Follow up?
Thank you. So I know that you said other states, you've seen these abuses and stuff in other states, but we're only dealing with New Hampshire law.
course.
Have you seen it in New Hampshire?
I don't have a specific New Hampshire case to point to.
Thank you.
Representative Raymond.
Thank you, Madam Chairman, and thank you for taking my question. So in what you just said, you said if they're, pursuing lawful mental health treatment or whatever. So say they're going to pastoral counseling or something. Here in New Hampshire, conversion therapy is illegal. Would this language saying that as long as it's, as long as they're acting consistent with their decision to raise their child, consistent with their biological sex, would that open the door for conversion therapy to make a comeback here in New Hampshire? Is it like a loophole?
Oh, I'm sorry. I think I can very confidently say that it would not. And the reason is if you look at the statute on conversion therapy in New Hampshire, it doesn't say what parents or anybody else can do except for licensed mental health professionals. And nothing about this bill changes the fact that it would still be unprofessional conduct under the 2018 New Hampshire law for licensed mental health professionals to engage in conversion therapy. And so the current law with respect to conversion therapy in New Hampshire would remain unchanged.
Thank you.
Representative Rice.
Thank you, Madam Chair. Thank you for taking my question. So I just have one concern. I am hoping you can clear it up for me. So say a child is cutting and is suicidal and the parent does nothing to seek treatment for that child. Would that then in turn still protect them from being neglectful?
So it seems to me that any of these kind of secondary effects, a child is harming themselves, they're engaged in cutting, they're refusing to eat, things like that. Those would, a parent's decision to make, a decision to seek or not seek medical treatment in that instance wouldn't be a decision based on the child's biological sex. It would be a decision based upon some other factor, and so it wouldn't fall within the parameters of this bill as I read it.
Thank you.
Representative Scher.
Thank you, Madam Chair. Again, thank you for taking the
Thank you.
question. Have you or the people you're working with here in New Hampshire talked to DCYF about what's happening on the ground in this regard in New Hampshire?
I have not, perhaps others have.
Thank you.
Any further questions from anyone? Seeing none, thank you very much.
Thank
for
you
your
so
time
much.
and answers. The next card I have is from Claire Abernathy. Thank you for coming today. As soon as you introduce yourself, you'll have 3 minutes.
Members of the committee, thank you for allowing me to speak today. My name is Claire Abernathy, and I'm a 21-year-old woman. But for 5 years, from the ages of 12 to 17, I believed that I was a transgender boy. By the age of 14, I began taking testosterone and underwent a double mastectomy in an effort to affirm that identity. I live with permanent medical issues as a result of those interventions, but that is not what I'm here to discuss today. Well before a needle or scalpel had pierced my body, I had already been harmed. Shortly before I had the mastectomy, my mother walked into my bedroom while I was sleeping, and she saw my bare chest. She told me that that moment had broken her heart, as my breasts closely resembled hers, the difference being that I was a 14-year-old 8th grader, and she was a 45-year-old mother who had breastfed 5 children. I haven't worn a breast finder in 7 years, and I still cannot walk long distances without the sharp pain of my ribs stabbing into the tissue beneath. This was not an intervention prescribed by any doctor. It's an incredibly common aspect of social affirmation. It is widely advertised to be safe and completely reversible. Breast binders could at one point be purchased at the Target store 3 miles from here. The harm was not only physical, it was social, psychological, familial, and spiritual. A few months into my social transition, my legal name and sex marker were changed, and I moved to a new school where no one knew that I was really a girl. This effectively isolated me from my peers. I was no longer seen as a girl, but never truly accepted as a boy. Boys and girls are different, both inherently due to neurobiology and due to the way that we are raised. My adolescent social development was stunted. Ordinary friendships and early romantic relationships became impossible. That isolation reinforced my belief that I was fundamentally different, broken, and wrong. Trans ideology taught me to interpret my discomfort through a narrow lens, that my body was the problem. Normal adolescent insecurity, trauma, and confusion were reframed as evidence that my identity was fixed and required medical intervention. There was no space to explore doubt because questioning the narrative itself was treated as harm. I was not encouraged to integrate my body, history, and personality into one coherent sense of self. I was taught to reject parts of myself as obstacles to overcome. That fractured my sense of wholeness and delayed genuine self-acceptance. This bill is important because it restores balance to this conversation. It makes it clear that a parent's choice to spare their child the harm inflicted on children like me, rather than affirm their belief that their body is wrong and must be changed, is not abusive and should never be used to justify removal, loss of custody, or adverse placement decisions. Children deserve better than the collusion of the adults in their life in their self-hatred. They deserve time. They deserve curiosity instead of a false veneer of certainty, and they deserve parents who are free to protect them without fear of punishment from the state. I urge you to support HB 1376. Thank you for your time.
Great job. Any questions, Representative Raymond?
Thank you, Madam Chairman, and thank you for coming and sharing your story with us. My question is whether or not DCYF in New Hampshire was involved in your process. Like, were you removed from your parent and then put through this while you were in the care of the state?
I'm from Texas.
Oh, okay. Thank you.
Representative Gregg.
Thank you, Madam Chair, and thank you so much for coming all this way to testify and for sharing your story. That was very brave. Did your parents, I assume were they supportive of your gender choices?
They wanted to get me help for the distress that I was clearly experiencing, and so they took me to therapists who they believed that they could trust.
Okay, follow up.
Follow up.
Got turned off. And did they feel like they had to because they would lose you if they didn't do that, or was it just their parenting style? You're off.
I'm not sure, you have to ask them.
Okay, thank you so much.
Representative Georges.
Thank you, Madam Chair. Thank you for coming far away. I think you was protected by your parents or you was not protected at the time?
It's a complicated question. I think that my parents were trying to protect me and that they had my best interest at heart, but that ultimately they failed to recognize the danger of the position that I was put in.
Follow up?
follow up.
For yourself now, what did you think? What your who? I'm sorry. Like if for today with your parent and yourself and your therapist or the state, who protect you at the time?
No one ultimately protected me.
Thank you.
Representative Petrino.
Thank you, Madam Chairwoman, and thank you for being here and giving your testimony. And I'm sorry to hear sincerely of the struggles that you endured. Would you believe that in this committee, we actually heard testimony quite the opposite of what you're presenting? We had a transgender woman come here to tell us of her experience being homeschooled with conservative Christian parents who daily talked about the sins of conversion. And as she sat there listening to her parents, the turmoil just built up inside her so much. She felt her parents didn't love her, didn't accept her. She considered suicide. All said and done, she still transitioned when she was a young woman. So I just would like to know, it's a real challenging situation. And so, the testimony you give, I hear it, but then there's the alternative situation so I just wanted to put that out there, see if you have any thoughts on that.
I'm not sure what the question is.
I don't think anybody is. Can you restate your question, Representative?
Yeah, the question basically is, can you see the other side of the coin on this issue? Because it's extremely challenging. And we're hearing your testimony, and I hear you, and I appreciate what you have to say. But can you recognize the alternative point of view where that individual did, in fact, transition and felt they did not have any support from their parents, did attempt suicide? And so your situation is one thing. We have the alternative, two sides to a coin. Mm-hmm. And so I just wanted to see if you recognize that, and how do we address that?
Yeah, of course, there are people whose experiences differ from mine. There are people who spiritual experiences, people with varying religious beliefs, they can raise their children in ways that ultimately their children feel were wrong for them and harmed them. I think the purpose of this legislation is to say that the choice not to affirm a child is not in and of itself an abusive one. That sounds like there were other things going on in the family dynamic that led to that individual experiencing mental distress. I'm sorry to hear about that person's experience, and I do recognize that people from all walks of life have different experiences.
Representative Gregg.
Thank you, Madam Chair. I just have a quick question. So, and I'm sorry to barrage you with questions. It's very brave what you did, and it's very hard to come up here and say these things. I wonder what this particular bill, I appreciate your testimony and stuff, but how does it relate to this bill? Like, how would this bill have helped you in your situation?
My situation is an example in which a child being affirmed harmed them. This bill is saying that a child not being affirmed is not definitionally abuse. So the way that the two relate would be that my parents would not have felt like there would have been legal precedent, saying that whatever choice that they made was their right and that they could raise me how they saw fit, essentially. My therapists, the way that it was presented to them was basically, if you do not affirm your child, they're going to die. If you do not socially transition, medically transition your child, you're harming them. and therapists are mandated reporters. My mom was a school counselor. She was well aware of that. I imagine that that did play a role in her decision, ultimately.
Thank you so much for your brave testimony. We really do appreciate it, and God bless you. I'm so glad that you're better and you're smiling. And thank you so much for coming. We appreciate you.
Thank you.
The next pink card I have is Simon Amaya Price. Thank you for coming. As soon as you introduce yourself, you'll have 3 minutes.
Yeah, thanks for having me. My name is Simon Amaya Price. I used to be trans, and I'm here to tell you that telling the truth is not child abuse. I arrived upon the conclusion that I was transgender when I was 14 years old, after a lifetime of bullying and shortly after being sexually assaulted by an older boy at my high school. I was a child in crisis, looking for answers. Why did I feel so uncomfortable in my body? Why didn't I get along with the other boys? At school, I was presented with answers to these questions. Instead of learning about the effects of puberty in health class, I was taught about the gender unicorn and shown videos by transgender YouTubers who taught me to categorize all my pain as gender dysphoria and evidence that I was in fact born in the wrong body. This wasn't just pushed at school. I still remember when my pediatrician asked my father, who refused to take me to the gender clinic, "Would you like a dead son or a living daughter?" I was in the room. My father stood his ground. He had the compassion and fortitude to say no to the irreversible hormones and surgeries that had been sold to me as a cure to my pain. That wasn't abuse. That was the love of a father who chose to fight the state and medical establishment who wanted to harm his son. HB 1376 empowers parents to make the decision to raise their children in accordance with reality, without having the coercive power of the state at their throats, so that fathers like mine do not have to feel like they are walking on eggshells to fight for the health of their sons. Due to state overreach, it took longer than otherwise it would have for me to get the mental health care that I needed for closing my opportunity to have a normal high school experience. Opponents of this bill will claim that gender dysphoric children are not harmed by social transition, and that, in fact, they will kill themselves if not affirmed. My colleague Clara Abernathy and I were both diagnosed with gender dysphoria, socially transitioned, and we are telling you here today that we were harmed. You can choose to listen to us, or you can choose to ignore us, the thousands of desisters and detransitioners here in New Hampshire and the hundreds of thousands throughout our great nation. Lastly, I would like to address some misconceptions. Socially transitioning children is gender-affirming care. It is a psychological intervention with long-term implications, which greatly increases the chance that when children grow into young adults, they will undergo these irreversible surgeries and take harmful pharmaceuticals. I was ideologically groomed into a transgender identity.
30 seconds.
And saying that I was really a girl inside was fundamentally ideological statement. Gender ideology has been argued to be a religion in legal settings in the US and the UK. And take it from someone who left. Gender ideology is at best a religion and at worst a cult. I am of the belief, along with most of my fellow Americans, that there are in fact certain ideologies which are incompatible with our society, including communism, radical Islam, and the newly invented gender ideology. And yes, New Hampshire law as written can be interpreted to say that not affirming your child's stated gender is abuse. I am happy to answer any or all questions. Thank you very much.
Thank you for coming and thank you for your testimony. Do I see any questions? Seeing none, thank you for being so brave to come before us today and give us the information you've given us. I appreciate
Thank you for
it
having me.
and you.
It's a little bit shameful that some of the Democratic representatives.
You're done. You're done, sir. Thank you. Your testimony was wonderful. I don't want to ruin it. Thank you. The next card I have is Nora Macklin. I'm sorry if I did not pronounce your name correctly.
My name is Nora Meckley.
Okay, now, there you go. Now you can introduce yourself, and then I'll give you 3 minutes.
Okay. So my name is Nora Meckley. I'm the mother of a transgender child, a physician, and weirdly, I've also been a foster parent for close to, off and on for 30 years. I have 2 adopted Afro-Latina daughters and 4 other children. I just been listening here, and so I just had to come. Like, I wasn't going to come this morning. I was like, they're talking about like everything that's important to me, so like, I guess I better come up. I'm from Boston. And I just wanted to answer the question about the data that you were saying. Do you know about these things? And that man was saying this is good for trans people. First of all, the majority of pediatric people who identify as a transgender desist. There was a large study from Germany. 64% of them, and that includes older people, change their mind, and 30% in a smaller study. So it's very clear that the majority, it's not good for trans people because most of these kids are not going to persist until they throughout adulthood. Also, the suicidality that somebody was talking about, there's been large studies that very conclusively show that there is indeed increased suicidality in the transgender population, but it is not related to the transgender in itself. It's due to underlying conditions. So it's important not to look at anecdotal cases of this person or that person. There is no increased, not affirming, so they're basically their increased rate of suicidality is not due to the transgenders, and it's due to secondary issues which are so common in the pediatric population, including ADHD, autism, depression, anxiety, all the things. There's no such things as new mental health problems, right? I mean, 20 years ago, I quit practice 17 years ago. I never one time in the tens of thousands of patients I saw in the ER and urgent care settings, never one time did I see a child with gender dysphoria or all this kind of stuff. This is all new. So what this really is new expressions of older mental health problems that are presenting in ways we never saw. The lady was saying, well, we don't have this in New Hampshire, so who cares? Like, let's just let it go. Well, if we know somebody's a pedophile, do we not say something before they do something? Like, if you know there's going to be a problem, why not just make the law now so that it's in place so that you don't have a problem in the future? And then as a foster parent, I would also say that in my experience, most of the times I get a call, it's because they got somebody sitting in their office and they need to put somebody in a house, right? They just call you up and say, can you take the kid, yes or no? And then, so like, where was I going with this? Oh, so you were saying like, oh, you know, when they're talking about a placement, you know, do they really take that to consider? Well, you know, it depends on who the social workers are, right? So just because it's never been a problem in New Hampshire, it could be
30
that
seconds.
there's a certain worker there who is, because there's some people who are like kind of warriors for this whole transgender thing. And if you happen to have one of those who's sitting in the meeting, you know, that could just change it. So you might as well just make a rule so that these kids who aren't going to get hurt in the future. I think I'm done.
Thank you. Questions? You did a great job.
Okay, good.
Thank you so much.
You're welcome.
It's very hard to sit there in front of all of us. Thank you. I have one final question, and that will be one final card. Thank you for correcting me. I'm tired. One final card. That's my Boston accent. Carl. Anyway, Mr. Donald Gilbert, if you would like to come forward, and you'll have 3 minutes as soon as you introduce yourself, sir.
Good afternoon, Chairman DeSimone and members of this committee. I was not actually here for this bill at all. I was just sitting and listening while waiting for our 3:30 meeting. But I felt compelled, based on some of your questions, to give you those real New Hampshire case datas specific to DCYF former policies, former being the operative word there. I do believe that those have since changed, but that would be a question for DCYF to correct it and see if they have changed their cultural awareness and their policies for gender reaffirming as being neglect under their internal policies. You may be aware, I'm not sure if I did go ahead back in 2024 and give notice to this committee or not, but my son was in residential treatment underneath JJS for juvenile justice. In that facility, there was a cultural appropriation for affirming gender identity and not wanting to overstep on those children, and it being abusive or neglectful for the facilities to go ahead and not affirm those genders. That was something that I worked diligently with the Attorney General's office and the Office of the Child Advocate for my own child to be fixed with the internal policies and the policies of this facility. My son still 2 years later still struggles with some of what we believe to have been abuse by a staff member propagating these transgender ideologies and gay operatives inside this facility. There was many children within my time visiting that facility over the 2 years that my child was there that I noticed many children significantly struggling with just day-to-day living based on these conflictings of not allowing these children the proper medical and mental health treatment that they needed to combat their gender dysphoria that they were experiencing. A lot of these children were also voluntarily placed through BCBH.
30 seconds.
Yep, thank you. And so it's not always necessarily the abuse and neglect aspect of that, but I do believe that this policy or this statute would have helped guideline the division earlier on and not had to have this cultural fix and these policy fixes that create a systematic abuse situation.
Thank you so much. And again, I appreciate your courage to come here and testify on such an emotional subject. We really appreciate your time and your effort. Are there any questions for Mr. Gilbert? I see none, but I thank you again.
Thank you, everybody.
We have one more card coming down. Madam, you might as well just come right up. Come on up, Shirley. Well, you're the last card. I thought, okay, just a minute. Put your mic on so we can hear you. Press the button.
Press the button down at the base.
There you go.
Okay, hello.
Shirley Harianto.
Yes, I am.
Thank
And
you.
as you all know, I still have open case, which is the division and the CYF still forcing to terminate my parental rights, and even still nobody pay attention or being concerned of my son being dressed up as a girl. I mentioned it that my son is a boy. I'm a Christian. As a parent, I do not mind that if he decides to become transgender. And I will support him as long as the age appropriate. But unfortunately, my son right now is still 4 years old, is not old enough to understand well. And then I feel like a foster parent still dressing him up, whatever they like to do, as dressing up as a girl. And I decline that. Is that what appropriate word is? I don't agree, basically. And if he old enough, like this all commentator behind me, and I will support these bills as long as doesn't separate the parents from the children, and the CYF didn't use that concerning of reasonable to terminate parental rights or whatever. I want to have children still able to be with their biological parents no matter what, unless it's very harmful and very neglect or abuse with all the evidence as bruising, hurt, or maybe hospitalized. Without that, I don't think that there's a reason to separate children by just gender or biological sex. That's what I believe, and I support this bill. Thank you very much.
Thank
Do you have
again
any
for coming.
question?
Does anybody have any questions? Seeing none, thank you for your bravery.
Thank you so much.
And bringing your story. I appreciate
Do I
it.
need to turn off?
Yes. Thank you. Having no more pink cards available, and I see nobody else requesting to come before us, I'm going to close the hearing on House Bill. Representative Gregg.
Can
you have
we
a
please
question?
ask for a researcher? I see that she's in here today. Can we please get some information on other states that maybe this bill, they have worked on this type of legislation or kind of what's happening across the United States, please? Because we had a lot more talk about what's going on in other states. I want to see what's happening with implementation.
You always have the opportunity to request that from the chair, and I'm very amenable to having you go to the committee assistant and ask her to get that research for you.
I was told anybody could ask the researcher to do that. But
You just have to go through the chair. But yeah, I just, and I've never, the people who have asked me to get research for them, I've never found a reason to decline.
Great.
So-
I just think it would be helpful for everybody at the
Sure.
on the committee.
Sure. Go right ahead. Thank you very much, everybody who came here today. I appreciate your time. I will now close the hearing on House Bill 1376.